Rule 12. Internal security operations. 12.1 General mandate. The PNP is mandated to provide active support to the Armed Forces of the Philippines, AFP, in internal security operations, ISO, for the suppression of the Communist Terrorist Movement, CTM, and other serious threats to national security. Executive Order No. 546 Series of 2006, directing the Philippine National Police to undertake active support to the Armed Forces of the Philippines, in internal security operations for the suppression of insurgency and other serious threats to national security, amending certain provisions of Executive Order No. 110 Series of 1999 and for other purposes. 12.2 The PNP in an active support role. The PNP shall perform the following. A. Conduct sustained law enforcement actions against CTM atrocities. B. In urban areas, the PNP may assume the lead role in ISO against the CTM, other threat groups and organized crime groups engaged in armed offensives. C. The PNP units may either operate as a single force or as a part of joint PNP-AFP combat operations. In both cases, lateral coordination is a must. D. The PNP units in CTM-affected areas may be placed under operational control, OPCON, of AFP units, but shall continue to perform law enforcement functions. E. Specific areas where armed confrontations such as encounter, ambush, raid, liquidation and other similar atrocities occur between government forces, PNP or AFP, and the communist terrorists, CTs, shall be treated as a crime scene. The police unit that has jurisdiction over the area shall conduct the crime scene investigation, CSI. 12.3 Defensive position. Police stations, especially those located in far-flung areas, are priority targets of attacks. As such, security measures against communist terrorist atrocities must be undertaken as follows. A. Continuously remind all PNP personnel to be extra vigilant and security conscious in their day-to-day activities and during troop movements.
B. Duty station guards shall memorize, internalize and put into practice the 11 general orders of a duty guard. Annex. Z. Likewise, they shall always carry their issued long firearms and ammunition rig bandoliers with basic load. C. Vigorously implement added security measures in all police stations and police community precincts. D. Conduct sustained inspection of the operational readiness of PNP field units stations. E. Always keep in mind the modus operandi, strategies and tactics being practiced, employed by the CTM and other threat groups. F. Enhance the establishment of Advanced Security Control Points ASCPs, to control the ingress and egress of people in police stations. G. One of the strategies and tactics employed by CTM and other threats groups, to gain access to police stations is by wearing of PNP AFP uniforms, and that of other law enforcement agencies. Hence, personnel assigned in the Advanced Security Control Points shall not allow entry of uniformed groups, or any individuals without prior coordination. 1. Exercise sustained vigilance and maintenance of law, order and public safety, in respective area of responsibility through the intensified conduct of police visibility patrols. 2. Carry out police community relation (PCR), barangay peacekeeping operations (BPO) activities in areas that are prone to influence, infiltration and infestation of communist terrorists group fronts organization.
Rule 13. Arrest. 13.1 General Guidelines. A. All arrests should be made only on the basis of a valid warrant of arrest issued by a competent authority, except in instances where the law allows warrantless arrest. B. No violence or unnecessary force shall be used in making an arrest, and the person to be arrested shall not be subjected to any greater restraint than what is necessary under the circumstances. C. As a general rule, arrests can be made on any day of the week and at any time of the day or night. D. Only judges are authorized to issue warrants of arrest.
E. A warrant of arrest is no longer needed if the accused is already under detention.
An order of commitment is issued by the judge in lieu of the warrant of arrest. F. The following are immune from arrest. 1. A senator or member of the House of the Representatives while Congress is in session for an offense punishable by not more than 6 years of imprisonment. And 2. Diplomatic agents, under the Vienna Convention on Diplomatic Relations. 13.2 Warrant of arrest. The warrant of arrest is the written authority of the arresting officer when making an arrest, or taking of a person into custody, in order that he may be bound to answer for the commission of an offense. The head of the office to whom the warrant of arrest has been delivered for implementation shall cause the warrant to be implemented within 10 days from receipt. Within 10 days after the expiration of such period, the police officer to whom it was assigned for implementation shall make a report to the judge who issued the warrant, and in case of his failure to implement the same, shall state the reasons thereof. 13.3 Arrests without a warrant. A peace officer or a private person may, without a warrant, arrest a person. A. When, in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. B. When an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. C. When the person to be arrested is a prisoner, who has escaped from a penal establishment, or place where he is serving final judgment, or temporarily confined, while his case is pending, or has escaped while being transferred from one confinement area to another. D. Where the accused released on bail attempts to leave the country without court permission. E. Violation of conditional pardon, punishable under Article 159 of the Revised Penal Code as a case of evasion of service of sentence. And F. Arrest following a deportation proceeding by the Immigration Commissioner against illegal and undesirable aliens. 13.4 Authority of the arresting officer when making an arrest. A. Police officer may summon assistance. A police officer making a lawful arrest may verbally summon as many persons as he deems necessary to assist him in effecting the arrest. B. Right of a police officer to break into building or enclosure. A police officer, in order to make an arrest, with or without warrant, may break into a building or enclosure where the person to be arrested is or is reasonably believed to be, if he is refused admittance thereto after announcing his authority and purpose. C. Right to break out from building or enclosure. Whenever a police officer has entered the building or enclosure to make an arrest, he may break out therefrom, when necessary, to liberate himself. D. Arrest after escape or rescue. If a person lawfully arrested escapes or is rescued, any person may immediately pursue to retake him without a warrant at any time, and in any place within the Philippines. 13.5 Procedures. A. Serving of warrant of arrest. 1. Verify the validity of the warrant and request for an authenticated copy from the issuing court. 2. In serving the warrant, the police officer should introduce himself and show proper identification. 3. Make a manifestation of authority against the person to be arrested. 4. If refused entry, the police officer may break into any residence, office, building, and other structure where the person to be arrested is in or is reasonably believed to be in, after announcing his purpose. 5. The police officer need not have a copy of the warrant in his possession at the time of the arrest. If the person arrested so requires, the warrant shall be shown to the arrested person as soon as possible. 6. Secure the person to be arrested and use handcuffs for the protection of the arresting officer, other individuals, or the arrested person himself. 7. Conduct thorough search for weapons and other illegal materials on the person arrested and surroundings within his immediate control. 8. Inform the person to be arrested of his rights under the law, example, Miranda warning and anti-torture warning. 9. No unnecessary force shall be used in making an arrest. 10. Confiscated evidence shall be properly documented, with the chain of custody of evidence, duly and clearly established. 11. Bring the arrested person to the police station for documentation. 12. Make a return of warrant to the court of origin. Annex B, return of warrant form. And 13. Deliver the arrested person to jail/prison upon the issuance of a commitment order of the court. B. Effecting warrantless arrest. 1. Freeze or restrain the suspect. 2. Make proper introduction as to identity and authority to arrest. 3. Inform the arrested person of the circumstances of his arrest, and recite the Miranda warning and anti-torture warning to him. 4. Secure the person to be arrested and use handcuffs for the protection of the arresting officer, other individuals, or the arrested person himself. 5. Conduct thorough search for weapons and other illegal materials on the person arrested and surroundings within his immediate control. 6. Confiscated evidence shall be properly documented with the chain of custody of evidence duly and clearly established. 7. No unnecessary force shall be used in making an arrest. And 8. Bring the arrested person to the police station for further investigation and disposition. 13.6 Duties of the arresting officer. A. It shall be the duty of the police officer implementing the warrant of arrest to deliver the arrested person without delay to the nearest police station or jail to record the fact of the arrest. B. At the time of the arrest, it shall be the duty of the arresting officer to inform the person arrested of the cause of the arrest, and the fact that a warrant had been issued for his arrest. The arresting officer need not have the warrant in his possession at the time of the arrest, but after the arrest, if the person arrested so requires, the warrant shall be shown to him as soon as possible. C. When women or children are among the arrested suspects, the arresting officer shall task the Women's and Children's Protection Desks, WCPD, officer or a policewoman who is familiar with Women and Children Protection Desk duties, to conduct the pat-down search. D. In case of arrest without a warrant, it shall be the duty of the arresting officer to inform the person to be arrested of his authority, and the cause of the arrest, except when he flees or forcibly resists before the arresting officer has the opportunity to inform him, or when the giving of such information will imperil the arrest. E. The person arrested, with or without warrant, shall be informed of his constitutional right to remain silent, and that any statement he makes could be used against him. Also, that he has the right to communicate with his lawyer or his immediate family, and the right to physical examination.
F. A person arrested without a warrant shall be immediately brought to the proper police station for investigation, without unnecessary delay.
He shall be subjected to inquest proceedings, within the time prescribed in Article 125 of the Revised Penal Code, RPC. G. No torture, force, violence, threat, intimidation, or any other means, which vitiate the free will shall be used against an arrested person. The bringing of arrested persons to secret detention places, solitary confinement, and the like is prohibited. H. If the person arrested without a warrant waives his right under the provisions of Article 125 of the Revised Penal Code, the arresting officer shall ensure that the former signs a waiver of detention in the presence of his counsel of choice. And I. If the person arrested waives his right against self-incrimination, and chooses to give his statement, the arresting officer shall ensure that the waiver is made in writing, and signed by the person arrested in the presence of a counsel of his own choice, or a competent and independent counsel provided by the government. 13.7 Physical examination of arrested person, suspect. Before interrogation, the person arrested shall have the right to be informed of his right to demand physical examination, by an independent and competent doctor of his own choice. If he cannot afford the services of a doctor of his own choice, he shall be provided by the state, with a competent and independent doctor, to conduct physical examination. If the person arrested is female, she shall be attended to preferably by a female doctor. Rule 14. Search and seizure. 14.1 Requisites for the issuance of search warrant. A search warrant shall be issued only upon probable cause in connection with one specific offense to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses presented. The search warrant shall particularly describe the place to be searched and the things to be seized, which may be anywhere in the Philippines. A. The following properties may be the objects of a search warrant. 1. Properties which are the subject of the offense. 2. Stolen, embezzled proceeds, or fruits of the offense. And 3. Objects including weapons, equipment, and other items used or intended to be used as the means of committing an offense. B. Objects that are illegal per se, even if not particularly described in the search warrant, may be seized under the plain view doctrine. 14.2 Validity of search warrant. A. The warrant shall be valid for 10 days from date of issuance and may be served at any day within the said period. Thereafter, it shall be void. B. If, in the implementation of the search warrant, its object or purpose cannot be accomplished in one day, the search can be continued the following day, or days, until completed, provided it is still within the 10-day validity period of the search warrant. C. If the object or purpose of the search warrant cannot be accomplished within the 10-day validity period, the responsible police officer conducting the search must file, before the issuing court, an application for the extension of the validity period of said search warrant. 14.3 time of search. The warrant should be served during daytime, unless there is a provision in the warrant allowing service at any time of the day or night. 14.4. Applications for search warrant. All applications for search warrant shall be approved for filing by the Chief of Office. The application shall indicate the following data. A. Office applying for the search warrant. B. Name of officer applicant. C. Name of the subject, if known. D. Address/places to be searched. E. Specific statement of things/articles to be seized, and F. Sketch of the place to be searched. All approved applications shall be recorded in a log book, duly maintained for the purpose, indicating the name of the applicant, name of the respondent, nature of the offense, and date of the application. Annexes C, C1 and C2. 14.5. Authority of police officers when conducting search. In the conduct of search, if after giving notice of his purpose and authority, the police officer is refused admittance to the place of search, he may break open any outer or inner door or window or any part of a house or anything therein to implement the warrant or liberate himself or any person lawfully aiding him when unlawfully detained therein. 14.6. Prohibited acts in the conduct of search by virtue of a search warrant. A. Houses, rooms, or other premises shall not be searched except in the presence of the lawful occupant thereof or any member of his family or, in the absence of the latter, in the presence of 2 witnesses of sufficient age and discretion residing in the same locality. B. Lawful personal properties, papers, and other valuables not specifically indicated or particularly described in the search warrant shall not be taken. 14.7. Inventory and delivery of property seized. A. The police officer who confiscates property under the warrant shall issue a detailed receipt of property seized to the lawful occupant of the premises, or in the absence of such occupant, shall do so in the presence of at least 2 witnesses of sufficient age and discretion residing in the same locality. B. The receipt shall likewise include items seized under the plain view doctrine. C. The police officer must then leave a receipt in the place in which he found the seized property and a duplicate copy thereof with any barangay official having jurisdiction over the place searched, Annexes D and D1, and D. The police officer must forthwith deliver the property seized to the judge who issued the warrant, together with an inventory thereof, duly verified under oath. Annexes E and E1. 14.8. Valid search and seizures without search warrant. A. Search made incidental to a valid arrest. A person lawfully arrested may be searched for dangerous weapons or anything which may be used or which may constitute proof in the commission of an offense, without a search warrant. The warrantless search and seizure as an incident to a lawful arrest may extend beyond the person of the arrested to include the premises or surroundings under his immediate control. B. Search of moving vehicles if the police officers who will conduct the search have reasonable or probable cause to believe, before the search, that either the motorist is a law offender or they will find the instrumentality or evidence pertaining to a crime in the vehicle to be searched, the vehicle may be stopped and subjected to an extensive search. C. Seizure of evidence in plain view. Any object in the plain view is subject to seizure and may be introduced as evidence. Requirements under the plain view doctrine are: 1. The police officer must have prior justification for an intrusion or, otherwise, must be in a position from which he can view a particular area. 2. The discovery of the evidence in plain view is unintentional. Or 3. It is immediately apparent to the police officer that the item he observes may be evidence of a crime, contraband, or is a valid subject of seizure. D. When there is waiver of the right or there is consented search. To constitute a waiver of this constitutional right, it must appear, first, that the right exists, second, that the person involved had knowledge, either actual or constructive, of the existence of such right, that said person had an actual intention to relinquish the right. E. Searches under stop and frisk rule. The police officer has the right to stop a citizen on the street, interrogate him, and pat him for weapons whenever he observes unusual conduct which convinces him that a criminal activity exists. F. Emergency and exigent circumstances. A search warrant could be validly dispensed with in cases of exigent and emergency situation, and the police officers have reasonable grounds to believe that a crime is being committed, and they have no opportunity to apply for a search warrant from the courts because the latter were closed. G. Tipped information. If the police officers have reasonable grounds to believe that the subjects are engaged in illegal activities, the tipped information is sufficient to provide probable cause to effect a warrantless search and seizure.
This presentation is prepared by Police Staff Sergeant Marlon Fernandez Anabeza, a bona fide member of PNP Class 2011-01, Batch Exodus. PNP Scout, Class 34-2012, Batch Sick Lab. PNP SWAT, Class 2014-01. Batch Hitman. PNP Criminal Investigation Course, Class 363-2015.